Welcome, everybody. Thanks so much for joining us this evening. I'm Moo Balcher. I'm Director of Primary Prevention at the Women's and Girls Emergency Centre in Sydney, which is a frontline domestic and family violence service. I'm delighted to be your MC for this evening for Too Little Too Much. Very much looking forward to some of the things that we're going to hear tonight and also the panel discussion. So let's get started. I'd like to begin by acknowledging the traditional custodians and sovereign people of the land across which we work, recognising their continuing connection to land, water, culture and community, and paying respect to elders past and present. I'd also like to extend that respect to any Aboriginal colleagues who may be joining us tonight. And on behalf of the panel members this evening, also paying respects to the elders and traditional owners of the land where they are. I'm on Gadigal land this evening, and acknowledging that sovereignty was never ceded, that this was, is, and always will be Aboriginal land. We've got a fantastic lineup for you this evening. I can't wait to introduce you to the panel, but just a couple of housekeeping things first. As you'd be aware, this webinar is being recorded. It'll be available on the CSPHN YouTube channel within the next couple of days. And at the end of the webinar, an evaluation survey will pop up on your screens as well. We'd really appreciate your feedback. And you need to complete that to allow us to issue certificates of attendance as well. So please make sure you stick around after the webinar has finished. Your audio and video are switched off because we're a fairly large group tonight, but we're keen to interact with you as much as possible. So please ensure that you submit any questions to the speakers in the Q&A function throughout the presentation. If you are looking for the Q&A function, hover over the toolbar at the bottom of your screen and please ask us questions. There are no questions that are stupid. The purpose for this evening is really for us to share as much as we possibly can in a fairly short period of time. There's a second webinar in a couple of weeks' time as well, which also aims to increase your knowledge and confidence about where to find information. So I'll be keeping an eye on the chat and my PH and colleagues will do the same, and we'll try and get to everybody's questions and comments. Just a little bit about self-care. This evening, we will be talking about abuse and violence. The statistics tell us that domestic and family violence is prevalent, complex and gendered, happens in every postcode, across every socio-demographic group, and there are victim survivors and people who use violence everywhere in every community. It's therefore highly likely that there'll be people in tonight's group who have experienced or are maybe even currently being impacted or even perhaps using abuse in their intimate partner or family relationships. Please know that there is help available. We've got some help numbers here. 1-800-RESPECT is the National Sexual Assault and Domestic and Family Violence Counselling Service. Lifeline, of course. Doctors for Doctors, which is a New South Wales crisis service, which is available for you as a health professional, and Men's Line Australia as well. I'm just going to do a quick poll, which should pop up any second. We just wanted to know if you can describe what best describes your profession. So if you can answer those for us, we will collate the answers and they'll come back to you shortly. It's just really good for us to get a sense of who's in the virtual room this evening. So just a bit of context as to why we're here this evening and what we're talking about. We have 3 experts presenting insights and some really practical tips in relation to reporting, responding, and recognising domestic and family violence. We're going to hear from all 3 of them, and then we're going to run through a case study as a panel discussion in the second half of the session. Recognise, Respond and Refer is a domestic and family violence pilot which has been funded by the Department of Health. It's part of a broader suite of measures to support the 4th action plan to prevent violence against women and their children, which is a longitudinal national plan, and the second national plan will be launched later this year. Broadly, this program aims to strengthen healthcare outcomes, and it's all about facilitating access to services that are efficient and evidence-based across the community. And it really, this project really aims to support primary care sectors, particularly through primary health networks. So it's being piloted in 6 PHNs across Australia, 1 in Queensland, 2 in Victoria and 3 here in New South Wales. The New South Wales PHNs are Central and Eastern Sydney, Hunter, New England, and the Central Coast and Nepean Blue Mountains. And we've got representatives from those PHNs here with us this evening. If you're interested in learning more about those services, the contact details will be displayed at the end of the session, and I highly recommend checking out some of the resources that they have on those PHN sites. So the objectives for this evening are really about understanding the legal obligations and ethical considerations surrounding recording domestic and family violence in general practice, understanding what's best practice and how to confidently report domestic and family violence, and critically understanding the subpoena process and how to respond as well. And just a bit of a disclaimer, we're not going to be able to give you the full suite of information. We can't hope to be able to share with you, everything in this space, but the intention of these webinars is really to provide an overview and some practical examples and expertise from the panelists. If you have any questions that relate to anything that is being shared this evening, please, as I said, chuck it in the Q&A, but also know that there are other places that you can get specific advice as well. And the information that we're presenting in this webinar this evening is correct as of today. This is a rapidly moving space, and laws and systems and procedures change pretty regularly. So this information may become out of date. So just make sure that you keep up to date with information that we're sharing this evening. And we'll be sharing a few resources in the chat function tonight that may be of interest, things like the link to the Royal Australian College of GPs White Book, for example, Safer Pathways, which is the system in the referral system in New South Wales, and the GP Toolkit. So let's get started. As I said, we have 3 experts who are going to present some really their insights into specific aspects of recognising, recording and reporting domestic violence. We'll have a couple of minutes for questions after each speaker's presentation, and then some time at the end for questions to the whole panel. So please do interact with us. So we're just going to start off with a case study, and this kind of frames the whole conversation. One of the reasons we are here this evening is that we know all too often systems don't work for people experiencing domestic and family violence. Sometimes that is a deliberate result of systems abuse. It might be that the person who's using violence deliberately aims to stop a victim survivor attempting to get the support that they might need. Other times it might be a lack of understanding about the nature of what's going on. And sometimes it's just not about, it's about not asking the right questions. So this is one of the things that we're really aiming to give you confidence to do this evening. This case study is based on a real set of circumstances. It pertains to a woman who experienced coercive control and had her medical notes subpoenaed for a family court case after she left the relationship. So Christina is 37 years old. She has 2 children. When her second child was born, her partner John, who was the father of her second child, forced her to sleep in another room with the baby. He never helped her care for the child. He treated her like a housemaid. He was in charge of the finances. He would often confuse her, make her think that she was going crazy, and would constantly put down her parenting. Christina experienced many other forms of emotional abuse and coercive control. There was no physical abuse in the relationship, and there was no history of police involvement or apprehended violence orders. Christina started to develop postnatal depression following the birth of her second child and would cry herself to sleep every night. She felt overwhelmed, especially after the birth of her second child. At all her postnatal appointments, she had a low mood score when she was assessed. And John, her partner, only ever came to one appointment with her. When asked about her relationship, she told her care team, including a psychologist, an obgyn, a GP and a midwife, that she and John were fighting a lot and things just weren't right at home. She also alluded to some of the ways that John had tried to control her and his emotional abuse. Christina's health workers didn't ask questions to explore what she meant when she said that they were fighting, or that she was being controlled, or that things just weren't right. So she didn't elaborate. She was asked by her care team whether she was experiencing domestic and family violence, but Christina said no. She'd been in a previous relationship where she had experienced physical violence. And she didn't understand that what John was doing to her in this relationship was also considered abusive and domestic and family violence. She thought it only included physical acts of violence. Christina was always afraid to go home from her appointments, and she had panic attacks on the way. Years later, Christina and John separated and ended up in family court with a parenting matter. John subpoenaed her medical notes for the previous 15 years. And the majority of the notes were of no relevance to the proceedings, but they were admitted into evidence. And this left Christina feeling as though John was able to continue his emotional abuse and coercive control through the court process, particularly as he was representing himself and had direct access to the notes. The examples of emotional abuse and coercive control that she'd mentioned to her health professionals at the time were absent from the notes, although there were many references to the fights that they'd had. The notes from the one appointment that John attended said he was a safe and supportive parent, and that there was no domestic and family violence in the relationship, but they did describe her postnatal depression. Despite her concerns about the safety of her child with John, the court made orders for him to spend unsupervised time with their child, mainly because there was no independent corroborative evidence of domestic and family violence. And sadly, but understandably, Christina says that she will not go to a support service again or speak to a health worker about what she's going through if she finds herself in those circumstances. She's worried about what will be written in the notes and how they may be used in family court proceedings should they ever end up back in court. So I'm going to stop sharing my screen now, and I'm going to introduce our first speaker this evening. Many of you, I think, will know of our first speaker. Dr. Libby Hindmarsh has been working in general practice for more than 30 years. And I've had the pleasure of knowing Libby for a little while now. So it's lovely to be working with you again, Libby. She's worked as a GP principal in Glebe, and following that in Aboriginal health on Elcho Island in the Northern Territory, and in an Aboriginal general practice on the outskirts of Sydney. Libby's been a GP supervisor and has been involved in many aspects of GP education. Since 1992, she's worked on projects with the Royal Australian College of GP in the area of family and domestic abuse and violence. She's a co-editor of the RACGP Domestic Abuse and Violence White Book with Professor Kelsey Hegarty. She's currently working on the 5th edition, Abuse and Violence, Working with Our Patients in General Practice. She's worked as a medical educator, doing clinical training visits to GP registrars, teaching mental health for RACGP Rural, and doing presentations, workshops and writing in the area of family domestic violence, mental health and advanced care planning. Libby's been involved in mentoring and supervising GPs. She's the chairperson for the RACGP Faculty of Specific Interest, Abuse and Violence in Families Network. And Libby's going to talk briefly about the role of GPs in recording domestic violence. So Libby, I'm going to hand over to you and say thank you for being here this evening, and welcome.
Thank you very much, Moo. It's very nice to be with you again. So just listen to the case, and it's got a few things to teach us, I think. So the case shows us that our records can later be subpoenaed by the court. So although that's not going to happen probably many times to us, it may well happen, and it's important for us to consider that. And in this case, the records were used against Christina and her children. So they weren't supportive of her, and certainly they were used by her husband, John, against her. The law has now changed so that when you're in the family court, the perpetrator is not allowed to cross-question the victim. But at the stage this happened, that was happening, and it was often very abusive. So the questions asked about involvement in domestic violence was answered in the negative, as there was no physical violence actually happening in the relationship. So it shows us how important it is to think about the way that we're asking these questions, and asking that question to Christina was answered in the negative, because in fact it was not happening. But there's a wide range of types of abuse that happen in these relationships, and we can think about them as physical and emotional and sexual and coercive. So Christina had suffered extensive emotional abuse and coercion in her relationship with John, which you can see in the case study, sort of written there, but the health professionals who were seeing her failed to ask the appropriate questions, or really to listen to what Christina was saying, because there were many clues. So, and then she had postnatal depression, which is an indicator of family and domestic abuse and violence may be happening. And as primary health carers, we need to know how to ask the questions and to listen very carefully to what we're told. We know from the evidence that 1 in 4 women presenting to general practice with depression are actually involved in some form of family and domestic abuse and violence. And it's very clear that that's what was happening to Christina. She was being emotionally abused. She was involved in coercive control. And in this case study, we don't know if there was sexual abuse, but it is highly likely that it was, but we wouldn't know unless we specifically asked about that. So Kelsey Higgett is the professor of at Melbourne University and runs the Safer Families program. And Kelsey says the first aid of family and domestic abuse and violence is ask. And when we ask, we need to use the appropriate questions and look at safety for Christina and for her children. So better care and good records could have made an enormous difference to Christina and her children, and the perpetrator, John, could have been held to account for his behaviour.
Thank you, Libby. That was an excellent introduction. I'm wondering if there are any questions from the audience, whether anybody has anything specific they'd like to ask Libby before we move on to the next speaker. Libby, I might just ask you if you could just share with us really briefly a couple of examples about how to ask questions, where you suspect there may be coercive control going on. Obviously, it's easy to ask about, physical injuries, but when we're talking about those patterns of power and control, how would you frame some of that?
Well, I think we need to start with a fairly open-ended question like, what's going on at home? But I think it's really important. Some people in Christina's situation will say, oh, it's okay, when it's really not okay. So whether they say it's okay or it's not okay, I think we need to go on asking some further questions. So what happens when you and John fight? Have you ever been afraid of John? How's John relating to the children? And then you might ask some very much more specific questions. You could ask about who's running the finances. You could ask about what she's allowed to do in terms of seeing family and friends. You could ask about how the children are and what their behaviour's like. So you're just using things to get a much better idea of what's sort of going on, and then being able to say to her that what's happening to her you perceive is a form of abuse. So if we only use the word violence, then somebody like Christina will say, I'm not involved in violence. And she was quite right in saying that. It wasn't physical violence, but it was an amazing amount of emotional abuse and coercion.
Yeah. Thanks, Libby. And I can see that Shannon's put a link to a YouTube video on starting the conversation about family violence. So strongly encourage people to go and take a look at that if they haven't had an opportunity to do so. Look forward to discussing this case study in a bit more detail after the other presentations. Thanks, Libby. I'm now going to introduce Rocky Ruperto, who is going to be talking to us this evening about legal obligations surrounding the recording of DD. Rocky has been with Avant since 2013, and he has a dual role. He's the legal and policy advisor in the advocacy, education and research team, and he's also a solicitor with Avant's Medico Legal Advisory Service. He provides legal advice to doctors and medical practices and develops a range of educational materials to help them reduce their risk and improve patient safety and quality in healthcare. And Rocky also advocates for changes to health-related legislation and policy with the aim of making a difference to the practice of medicine and the Australian healthcare system. Thanks so much for joining us this evening, Rocky. I'm going to pass over to you.
My pleasure, Moo, and thank you for that introduction, and thank you, Libby, and also Pip. Thank you all for joining us tonight on this very cold night, but it is for a very important topic. I'm joining you tonight from Gadigal land as well. And tonight I am talking about the legal obligations when recording domestic and family violence. And so hopefully this isn't too much of a daunting task. I think that most of the obligations stay the same. And what I'm going to talk about tonight is where those legal obligations come from and how they might be specific to this topic. So just bear with me for one moment. I'm going to try and share my screen to show you some slides. Here we go. Hopefully everyone can see those. Libby nodding, I can see you nodding. Okay, perfect. So we'll start at the very start. It's always a good, we'll start at the beginning. It's always a good place to start. And so that's the purpose of medical records. So we know that the primary purpose is to assist in patient management. And that's the same for domestic and for victims of domestic and family violence. Your records should be able to assist you in the management of that person, of that victim survivor. But this also includes helping another doctor pick up the record and provide optimum care. So a medical record should be able to be read with understanding by any other doctor or healthcare practitioner that ends up with them. So unlike that little example that I have down the bottom. And this is particularly important in this area because sometimes, particularly with Christina and her child, that example, the records may, the amount of records may span a number of years. So if you are the health practitioner assisting Christina or other victim survivors, she might go to multiple, or she might, move around, she might be transient. And so it really is important that your medical records make sense to other medical or healthcare practitioners who are involved in the care of all your patients, but it's particularly important for victim survivors. Interestingly, and I'll talk a little bit about this, medical records are also used as an indicator of the standard of care. And I can share with you some of advanced research when we've looked into our members' claims and complaints. And I'll show you some statistics about what the correlation is between the quality of the medical record and the standard of care provided to the patient. And importantly, documentation is critical for the adequate care of the victim, as well as for any follow-up, and particularly if there's a legal process involved, which is often unknown at the time of medical intervention and the time that Christina or other victim survivors first see their medical practitioners. It's not known what's going to happen down the track. So it is really critical that documentation is there, that it's done right, it's comprehensive, because it could be used later on, and that's something you just don't know at the time. So what are medical records? Look, it's a really general term, and I do speak to doctors on our medico-legal advice line every week. And I even had a pediatric psychiatrist speak to me this week, and she was just flabbergasted to learn that her written notes formed part of the medical record, and that a patient could ask for them, or that in fact they could be subpoenaed. She thought because they were handwritten, it was her impression that that they belonged to her and they weren't part of the medical record. So all these things do form part of the medical record, and it is really important to understand that when you are either doing your electronic notes or your handwritten notes, the patient can request these and they also can be subpoenaed. But it also includes any referrals. Importantly for GPs, it also includes specialist reports. And I know a lot of specialists on the bottom of their letters will put things like, please do not share this. This is, my property, or something like that, and don't share it with anyone without getting my written permission. Now that doesn't hold any real legal weight if it is part of the record, the medical record. While doctors might be the owners of those records, patients have rights to access their records, and accessing those rights is enshrined in the Privacy Act, the Commonwealth's Privacy Act. So that applies across the whole country. So if specialist reports and letters are in your records and that specialist has written it on the bottom, it might be, a matter of professional courtesy to give that specialist a heads up that you are going to share it with the patient. And then they might make a call about, well, there is something in there, particularly if it's a psychiatrist or a pediatrician, there is something in there that I'm am worried about the patient's safety, and I would prefer to give it to them because I can explain the context of that letter. So if you are faced with that situation, you might want to give that specialist a call, but specialist letters really do form part of a medical record, and patients do have rights of access to those. Any resources that you give to patients. So in this context, it could be any referral brochures or information to support services that would fall under there. That all forms part of the medical record, and you should be documenting what you are giving the patient. Any hospital discharge summaries, which is really relevant as well for this particular topic. Investigation reports, photographs during your consultations with the patients. If they do have any physical injuries on them, taking photographs is really important, or any other electronic images that they might have on their phone that they share with you. That all does form part of the medical record. And lastly, any administrative documents such as appointment books and account records. So I know this may seem fairly basic, but you can see how these different things really do add up and can be important to help a victim survivor of domestic violence, and also how they are specific to this situation as well. Now, this is the investigation of our own claims and complaints data that I was speaking about. So this analysis is done on over 8,000 complaints to regulators and compensation claims for Avant members from all specialties over a span of about 3 years. And what we found was that poor record keeping was frequently associated with an inadequate standard of care. So when a claim or a complaint comes into us, we have to make some kind of judgment, and we do this with the advice of lawyers and doctors to decide whether or not the standard of care was met. And then the ultimate judge will be if it does go to trial. But what we found was that poor record keeping was frequently associated with an inadequate standard of care. So that's something to keep in mind. And it says something about what medical records can do for you and what you can do for the patient and the outcome that they receive. Now, poor record keeping was also identified in 1 in every 9 of our claims. So that's a pretty significant amount. It was rarely the main issue, but it did pop up quite frequently, and it was attached to the main issue. So when a doctor didn't meet the standard of care, in 25% of those claims, it also meant that they had poor records. So there is a strong correlation there. Now, talking about the legal obligations and where, those bits of law exist, they do come from all over. So I'm going to start first with the Medical Board's Code of Conduct. So that's good medical practice, and that really outlines your ethical and professional obligations. Now, it's important to be familiar with your obligations under the Medical Board's Code of Conduct because it describes what is expected of doctors registered to practice medicine in Australia, and it sets out the principles that categorise good medical practice, but makes explicit the standards of ethical and professional conduct expected by doctors, by their professional peers, and by the community. So a community member like Christina can pick this up, and that's the level of professional standards that she can really expect from her medical practitioners. And I can see from that poll, we do have psychologists and we do have nurses on the line, and there are other codes of conduct for each of the health professionals. And I'm not as familiar with those ones as I am with the ones for doctors, but I would, bet my last dollar that they would also have something about the documentation standards in there. So it is important to familiarize yourself with it. And the Code of Conduct is not only there to support doctors with the challenging task of providing good medical practice, but it's also there to assist the medical board in its role of protecting the public by setting and maintaining standards of medical practice against which a doctor's professional conduct can be evaluated. So if Christina ever made a complaint about her doctor, and the other medical practitioners that she saw, and she would probably have grounds to make a complaint to, in New South Wales, it would be the HCCC, or she might start to APRA and they would send it to the HCCC. They would be using documents like the Code of Conduct to evaluate what the records showed. And so it's really good idea to familiarize yourself with what they say. And to make it easier, I have pulled out the important parts for us tonight about medical records. And it says that doctors should maintain clear and accurate medical records because it's essential for the continuing good care of patients. Now, I've pulled out a couple of the sub-clauses, and the first one I think is very specific to this topic. It says keeping accurate, good medical practice involves keeping accurate, up-to-date and legible records that report relevant details of clinical history, clinical findings, investigations, diagnosis, information given to patients, medication, referrals and other management in the form that can be understood by other health practitioners. And this next one is also really important for this particular topic. It says ensuring that your medical records show respect for your patients and do not include demeaning or derogatory remarks. So making sure that they are really objective and your personal views about the situation are not put in there in a demeaning or a derogatory way. Now, the next piece of kind of legal obligation or the law where it comes from is this one. It's the health practitioner regulation specific to New South Wales. So New South Wales is one of the few states that actually has enshrined what is required in a medical record in legislation. And so this is really important for practitioners in New South Wales to know about. And I'm not going to read everything there again, but I will just highlight the bolded part there. And it says that a record must include the following. And so it says an information known to the medical practitioner who provides a medical treatment or other medical services to the patient that's relevant to the patient's diagnosis or treatment, which includes the medical history, also the results of any physical examination of the patient, information obtained concerning the patient's mental state. So we know Christina came in and she did have postnatal depression. Her mental state would have been really critical for doctors to document in the medical records, and not only for her care, but also because it's the law. This piece of legislation in New South Wales says that you do have to contain in the medical record any information concerning their mental state. Also, any results of any tests performed on the patient, and information concerning allergies or other factors that require special consideration. Now, that other factors that may require special consideration is quite broad, and I would think, I don't even have to argue, I would really be confident in saying that that would also include, their circumstance of being in this domestically violent relationship. Now, the last piece of law that I wanted to put up there was the RACGP White Book. Now, this one's really important because often when we do look at whether or not a practitioner has met the standard of care, we have this really ambiguous, sometimes unhelpful test in the law called, what would the reasonable practitioner do in this situation? So we have to think, well, who is the reasonable GP? And when deciding who that is, what we look at is standards put out by, organizations like the RACGP. So standards by the RACGP, if a GP was ever involved in a complaint or a compensation claim, standards would be something that would have a really high evidentiary burden or standard for that person's conduct to be judged against. So that's why standards such as the White Book are so important. And I would argue that they are basically becoming, the law themselves, because it is the standard of care expected by GPs. It's put out by the Scientific College. And when we are looking to decide what is the standard of care, particularly before anything has happened, we would turn to things like standards in the area. So I think it's important to familiarize yourself with what is in the RACGP White Book. And it does say in there that in the case of domestic and family violence, it's important to document both information the woman has given you in a factually accurate way, and also your own observations of injuries, her mood, and any other conditions and anything else that is relevant. The note should always be detailed, and documentation is critical for the adequate care of the victim, as well as follow-up should there be any legal process, which, like I said before, is really unlikely to be known at the time of medical intervention. So what the White Book suggests is that you should be entering in the medical record any health complaints, symptoms, and signs as you would for any other patient, including a history of who injured the patient. Describe every injury, including its location, size, and age. And this is important not only in case you have to write a police report, but having a reminder to yourself of what injuries look like and how they develop or how they go over time is, from a medical point of view, in fact, really valuable information. You'd consider photographing the injuries, but before you do that, gain consent from the patient to photograph the injuries and explain what those photographs are going to be used for. So they are there for your own scientific and clinical information. You as a doctor need to know how these things are developing, but also they could be used for police reports later on. Include what the patient said using quotation marks, and record any relevant behavior you observed. So the example they use is the patient cried when she spoke about, perhaps the situation that she was going through. Now, the cause of suspected cause of these injuries or other conditions is also really important to put into the medical record. And this is important for follow-up purposes and to remind yourself or to alert other practitioners at other visits. Codes or stickers in records are useful. So if you think that, or if the patient is particularly worried about, her records being found by her partner, or if you can't really guarantee the confidentiality of the records for whatever reason, some practices use codes or stickers in the records to highlight that this patient is a victim of domestic and family violence. And also it does help the next practitioner, if it's not you, to continue that care. And also it says that you should be putting a plan together for the patient, including any follow-up or referral services, and they definitely should be documented inside the medical record. Now, some questions, well, probably the main question we get from members when I'm on our medico-legal advice line is what to do if the patient asks you not to record it. And this puts you in a really difficult position because, you have all these legal obligations, which I've just highlighted. There's some from the standards that are set by the medical board in your code of conduct, your ethical and professional obligations. There's legislation in New South Wales, and there's also these standards set by your college. So, but then on the other side, you have your patient pleading with you not to record it. And that might be for any number of reasons. And so what I tell doctors is this could be a little checklist that you could go through, explain that it is confidential. Your records are confidential. And besides being subpoenaed, there aren't situations where people should be getting their hands on your medical records. And that includes, if part of a victim survivor's health record was included in somebody else's. So sometimes in a child's medical record, for example, there may be information about the mother. And if the father asks to see the child's medical record, if that would burden the mother, or if that would unfairly give away her health information, you as health practitioners can decline that request. And I urge you to do so. And if you are unsure about it, give us a ring or give your medical defence organisation a ring so you can discuss it. But you can object to sharing those medical records if they would unfairly breach the privacy of somebody else. So explain that it's confidential, explain that you have legal obligations to take to make these records. So as I've just said, you have lots of legal obligations. So pick any of them and just explain to your patient that you are legally obliged to make notes about the medical consultation, and explain how they can be helpful. Explain that, even if you take notes today, or even if they haven't decided to start that legal process, or they might not even be thinking about that in 1 year's time, 2 years' time, 3 years' time, when they are seeking that kind of reprieve, these notes could be really helpful for them, and not only for them, for their children as well. And you might have some anecdotes about how, of course, in a very confidential way, your note-taking have helped other people. And I think that would be appropriate to share, provided it is completely confidential, because these notes can be really helpful, not only to the victim survivor, but also for their loved ones, like their children. So that's it from me, unless there's any questions, and I'll certainly be sticking around to answer any of those. Thank you.
Thanks, Rocky. There is a question, and I just wanted to acknowledge that there's been another question from an audience member. Anne has asked what can be done about this type of abuse, i.e. non-physically violent. We might save that one for the panel to discuss at the end, but Rocky, Daniela was asking, can you comment on the use of the term alleged? Many health workers believe if they don't preface a DV disclosure with this word, they could be sued by the perpetrator. Can you comment on that?
Yeah, interesting question. Thank you. I don't think that you need to worry about that. I don't think you need to use the word alleged. I mean, everything that a patient tells you in a consultation is alleged, really, unless you can, besides your factual and objective tests and things like that, everything's alleged. So I wouldn't bother about prefacing everything with alleged. If a patient has told you something, you can say, patient said this, patient told you, because that's where you're gathering the information. So I don't think that you need to, if the perpetrator did get their hands on it, I'm trying to think of what the damage to them would be if that word wasn't there. I'm thinking defamatory, but in order for things to be defamatory, they have to be published and people have to see them. And I just can't see the context in which somebody's medical records would be published in that sort of way. So I don't think it's neither here nor there. I wouldn't bother. Actually, I think you probably wouldn't do it, because if the patient ever saw that, I think it would be more damaging for the patient to see that you had written alleged, and that's your that person is your priority. So in fact, I've talked myself around, scrapped the word altogether, scrap it altogether.
Thanks, Rocky. That's an awesome answer. And actually, as somebody working in a frontline service, we've had these conversations as well. You know, do you use the word perpetrator? What we tend to do is advise, when our case managers are making notes, just to use the name of the person that's, you know, using violence. So however that person in front of you, the victim survivor, is referring to partner, ex-partner, you know, whether it's by name, just use a name rather than having to struggle over the years using the word perpetrator. That's just a tip for the way that we do it in the front line.
I think that's nice.
Thanks, Rocky. Our final speaker this evening is Pip Davis. Pip is the Principal Solicitor at Women's Legal Service New South Wales, and she's worked in community legal services for more than 20 years, the last 9 years of those at Women's Legal. Pip sits on the New South Wales Domestic and Family Violence and Sexual Assault Council. She's a member of the New South Wales Law Society Family Law Issues Committee and the Greater Sydney Family Law Pathways Network. And she's previously provided training to the primary health pathways on screening for domestic and family violence. Pip's going to share a detailed insight into best practice record keeping and responding to subpoenas. Thanks, Pip.
Thanks, Moo. And thanks, Rocky, for that great presentation. It was really interesting, and you know, I think a great reminder around the importance of record keeping. And I loved your answer to whether or not we should use the word alleged perpetrator, and I agree with you. I don't think that it's a risk. Thanks also, Libby, for your introduction to Christina and some of the challenges that she faced as a result of poor record keeping in large part. So I'm just going to start to share my screen. Hopefully everybody can see that. Is that okay? All right. I am joining you this evening from Darraglands, and I'd like to pay my respects to elders past, present and emerging. All right, I'm going to flick through some of these early slides, both because they're introductory, or you can go back and have a look at them later, or some of them are going to are really just reiterating some of the messages that Rocky has given to us. So just bear, and I'm also mindful of the time, and I'd really like us to have a great conversation as a panel about Christina, so I don't want to eat into that time. All right, so just very briefly, Women's Legal Service New South Wales, so we're a statewide specialist community legal centre for women, and we specialise in working with women affected by violence. We're non-profit, non-government, and we offer free legal services. So that ranges from legal advice and legal assistance along the way, right through to representation for women in their legal matters. And we also do a lot of work around law reform and policy reform and community education, such as this evening. And we've got a great website, and I'd encourage you to find out a bit more by going to our website. Of interest also to some of you might be our platform called Ask Lois, and we have monthly webinars on a variety of different topics that are relevant to women experiencing violence. There's lots of resources on there. You can look at those webinars after they've been given live, and there's lots of fact sheets. So I would encourage you to have a look at that platform as well. All right, so what I'm going to talk about today is record creation. And as I said, I'm going to skip over a lot of that because Rocky's already covered off on that in such a fabulous way. I'm going to talk about requests for information, including subpoenas. And I'm going to briefly talk with you about two of the privileges, so sexual assault communications privilege and another of the privilege, the professional privilege. And I'm going to just also very briefly talk about some of the ways that notes might be used in court or other legal proceedings. All right, so record creation. So why do you create them? So we've heard from Rocky about all of those ranges of purposes and all of the obligations that you have around the creation and storage of those records. What I would say to you, I guess, just to pick up on Libby's opening remarks, is that it is possible that your records will be subpoenaed, but what I would encourage you to do is to not be intimidated by that and use that as a reason not to create good records. It's really important to create really good, sound, solid records of those services that you've provided to your patients. One of the obligations that Rocky touched on said explicitly that those records are to be understood by other health professionals. I would also encourage you to think about those who are not medically trained, and we often struggle to try and decipher medical records, particularly those that are handwritten, and the move toward electronic records has really alleviated a lot of that spelling and handwriting issues that is really common in those earlier records before computers. But also using terminology or abbreviations can just make it really, really difficult. And so when those documents particularly find their way into legal proceedings, it can be really challenging. So I would encourage you to consider how those records might be later used and the need for them to be clear and understood. All right, again, this is really just going over what Rocky talked about, but I will just just go to point number 3. So clearly identifying the patient and anyone else who was present. So when you think about Christina, there was that one instance where John was present with her in the interview. So it would be really important to note that if you're working with somebody and a patient and they're accompanied by anybody, but particularly the person who is the perpetrator of violence or who you may fear may be perpetrating violence, to just note that he was there at the time and present, so that it's very clear, particularly if later on there might be questions raised as to why it was that she didn't disclose violence. If it's clear that there was somebody else present, then it's an easier way to also explain why that may have affected a disclosure. All right, so continuing on. So making sure that, that your medical records are factual, that they're chronological, that they're using plain language. We've talked a lot about outlining what was discussed and using direct speech, not using unsubstantiated opinions. So being really careful about the statements that you make that really can't be substantiated. So again, to go back to Christina's scenario, one of those health professionals noted that that John is I think a supportive, hold on one second, a safe and supportive parent, and that there was no domestic and family violence in the relationship. It's not clear from the other parts of this scenario how it could be that a health professional could have made that statement or an opinion based on all of the other presenting issues that Christina has identified. All right, so let's move on to talking about documenting domestic, family and sexual violence. So it's really important that medical records explicitly identify that a patient is a victim survivor of domestic and family and sexual violence. So noting in direct speech the patient's report of violence. Importantly, and Libby talked about this in the beginning, talking about all of the different types of violence. So really asking direct and indirect questions that cover off on all of those different types. So physical violence, verbal violence, emotional abuse, control, financial abuse. So asking really specific and often direct questions. So the research shows us that clients or patients are much less likely to disclose a history of violence unless they're asked, and that direct questions supported by indirect questions or open questions, are best to then elicit a domestic violence history, particularly if somebody is reluctant or struggling to articulate or to disclose. So keep in mind the real need to try and unpack all of the different experiences of violence. And often people like Christina will say, oh, no, I haven't experienced any violence. And that's really common with our clients as well. But when you start to unpack what's going on and what's led to them coming to speak with us that day to get some legal advice, in fact, there's a whole lot of violence or abuse that's happening in their relationship. And so there is, in light of, I suppose some of it comes down to language. So violence has always been related to often physical violence, but often the word abuse is more general in its terms and can better capture different types of violence or abuse. And so keeping in mind the use of the word abuse may in fact also elicit better responses from your clients. Noting the dates and the years of domestic and the violence, so being as explicit as you possibly can. So is it that that this is the first time you've seen your patient and your patient says that this is a one-off, or is she saying that this has been happening for 10 years or 15 years, or are you able to see from the history that in fact there may have been previous treatment provided to her for incidents that were consistent with domestic and family violence. And also, it's very obvious, but noting that date of the consult. And so for me as a lawyer, when I'm looking at that date of the consult, aside from that obviously being some good record keeping, this is really important in terms of injury, so physical injuries, but also importantly psychological injuries. So if my client has seen a doctor and was diagnosed with depression or symptoms consistent with depression in 2015, then when she comes to see me and I might be running a case for her in 2020 and her doctor would still say, yes, she's suffering from depression or symptoms consistent with, then I would say that that's then a chronic psychological injury. So it's really relevant in terms of later court action. All right, so Rocky has talked with us about taking photographs of injuries if possible and with consent, so listing that location and the types of injury or injuries, including a description about the nature or details of those injuries. So if it's a bruise, does it look like it's a fresh bruise? Does it look like it's 3 days old? Again, this is relevant. It might not seem so relevant until later on when you might have, your records might be being used by a patient who might be doing a victim support claim, and they might have got medical treatment, say 3 days later, but you're trying to then tie it back to an assault or an act of violence that might have happened 3 days or a week before. And so it's really relevant in terms of sometimes the progression of these physical injuries, and outlining treatment and noting any referrals. In terms of psychological injuries, so noting that the patient what it is that the patient is self-reporting as to their presenting issues, ideally again in direct speech. So being able to describe all those non-physical indicators of injury and harm, so sleeplessness, depression, anxiety, weight loss or weight gain. Noting any diagnoses, including any tests that you might have administered and their results. Outline any treatment, including prescription of medication, and again, noting any referrals. These are all really relevant pieces of information when medical records find their way into many court proceedings. And finally, documenting your reasons for your belief that your client is presenting as a victim of violence. So, you know, it might be that she's presenting with particular injuries and you say, well, they are consistent with an assault to the face, for example. So it might even be that your client doesn't feel comfortable or able to disclose, or she might have had the perpetrator with her, but you in your records could say, she didn't disclose, but I'm concerned that she's been a victim of domestic and family violence, and for these reasons. Documenting as well your patient's assessment of their safety or the safety of their children, and also any protective measures that they may have in place. So do they have an AVO for their protection? Have they reported to the police? Do they have family support? Have they told their family or good friends about what's happening? Do they have safety plans in place? And also importantly, documenting your assessment of the risk of future or ongoing threat of further harm or lethality. So really doing a risk assessment with your patient or on your patient to help you to assess that assessment of future risk. All right, let's move on to requests for information. So there's lots of different ways that you could get a request for records or documents. So that could be via a subpoena. It could be via a Chapter 16A request under the Care and Protection Act. It could be under a Part 13A under the domestic violence legislation. It could be under a HRIPA application or some other freedom of information application. It could be an informal request, so not a summons or not a subpoena, but an informal request on behalf of the patient or an informal request from somebody else about the patient. Or it could be a different type of request. So for example, your patient might ask you to complete a certificate of injury form for her victim support claim, or you might be being asked by a victim survivor of domestic and family violence to complete a declaration for a termination of a tenancy notice, and I'll talk about that a bit later on. All right, so let's say you get this request for records or documents and you need to respond. So a couple of things to think about. So who's made that request? Is it the patient or is it somebody else? Do you need to comply with the request? So if it's a subpoena, it'll be different to if it is, let's say, a lawyer for the other party to your patient. So that let's say it's John's lawyer writing about Christina, wanting Christina's records and just sending a general letter. You don't need to comply with that request. It would be different if it was a summons or a subpoena. Has the request been properly made? So, does it have client consent? So if I'm writing a letter to you as a general practitioner, asking for you to produce my client's records for use in in a matter that I might be representing her in, it wouldn't be properly made unless it had a client signed consent authorising you to release those documents. And if it's a subpoena or a summons, then there are particular legalities that need to be complied with, and I'll come to that in a minute. What's the purpose of those records? And hopefully that might be clear from the document itself, but thinking through, well, what are they going to be used for? Do you need your patient's consent to release the records? And even if consent to release isn't required, should I tell my patient about the request? And if you're working with a victim survivor and it's about her records, I would say that it is very good practice to tell her that somebody has asked for documents about her. All right, so let's have a quick talk about responding to subpoenas. So who's the subpoena addressed to? So having a think about, has it been addressed properly? Is it addressed to the practice and so on? Who's requested or issued that subpoena? What exactly are they asking for? So, are they asking just for some specific types of documents, or are they asking for all of the records? What does your patient want you to do? What do I or my practice want to do? So what are your policies? What are the laws? And does it meet all the technical requirements? And are there grounds to object to producing the documents? So I'm going to have a look, I'm going to have a talk with you now about those last 2 points. All right, so challenging a subpoena. I guess what I will preface these next few slides with is really just to say that if you receive a subpoena, you generally speaking, you're going to need to comply and you're going to need to produce the documents. But just because you produce the documents doesn't mean that those documents should be used and that there aren't grounds to object. And so what I would encourage you to think through is whether or not you should be objecting and seeking to protect those documents from being used in legal proceedings and for being by being produced. So it really is just what I want you to think about is whether you should just produce those documents or whether you should go to somebody like Rocky or your own legal department, depending on where you're working, to really get some advice about the subpoena and whether or not there are grounds to challenge that subpoena or to limit the information that might go in. So there are technical obligations on the issuing of a subpoena. So it needs to be valid. So it needs to be, in some circumstances in the family court, subpoenas can only be issued if there's been leave of the court to issue that subpoena. Is it a subpoena that has been sealed by the court? So has it got the court stamp on it? If not, then they're not valid subpoenas. Has it been issued with enough notice? So there are notice requirements. When you're issued with a subpoena, you need to be given that with sufficient time to provide those documents to the court. And if it haven't been given enough time, then it's not a valid subpoena. If there's not enough time to comply with the request because of the magnitude of the documents, then also that might be an invalid subpoena. Or there might be a lack of conduct money. So that's the money that you're required to send with a subpoena to assist with the production of those documents. All right, there also might be some other reasons for challenging a subpoena. So it might be that the subpoena lacks a legitimate forensic purpose. So it's not relevant to the proceedings that are in court. It might be an abusive process. So it could be that it's seeking documents that you're not able to seek and you're not allowed to produce. So it could be that that somebody is seeking documents that relate to a report to the Department of Communities and Justice. And so that would be an abusive process. That the subpoena is oppressive, so that it would be so manifestly unfair to try and wade their way through all of these documents, and the magnitude of documents might be so much that it would just be too oppressive to produce. It might be a fishing expedition, so it's so broad, and really what a subpoena is when it's a fishing expedition is an attempt to just try and find out really whether or not there might be a case to answer, rather than the purpose of a subpoena, which is to produce a specific type of informational document, whereas a fishing expedition is really just seeing what's out there that might otherwise be used. And the final reason is that the requested documents are privileged. All right, so we're going to just talk about the two privileges very quickly. So the two that I'm going to talk about is sexual assault communications privilege, and then I'm going to turn briefly to talk about professional confidential relationship privilege. So the sexual assault communication privilege applies not across all types of, not all courts and not all types of matters, but it is really important for you to be aware that this privilege applies, and that it would then be grounds not to produce documents or not to have those documents admitted into court. So the sexual assault communications privilege applies to all criminal proceedings in New South Wales, even if it doesn't relate to a sexual assault offence. It also relates to AVO proceedings in New South Wales, and quite a limited range of civil proceedings. And really those are only where there might be a civil proceedings that follow criminal proceedings. So it might be there's been some criminal proceedings and then there might be some civil proceedings. Let's say there's a personal injury claim that may arise out of the civil proceedings, or it might be a defamation proceedings. And also where the facts are substantially the same as those that were in the criminal proceedings, and where sexual assault communication privilege was successfully upheld in the criminal proceedings. Importantly and relevantly for Christina, had she disclosed a history of sexual violence to her health practitioners and those records were documented, or those reports were documented in her health records, it doesn't apply in family law proceedings. That doesn't mean the records automatically go in, but the sexual assault communications privilege, unfortunately, doesn't apply to family law proceedings. All right, so what records could be protected? So any counselling communications that are made by, to, or about a victim or an alleged victim of sexual assault. And those that are made in confidence to another person, so the counsellor who's counselling the person in relation to any harm they may have suffered. It includes any records that were created before or after the alleged sexual assault. So it's quite broad, and also broad in that those records don't have to be about the sexual assault or a sexual assault. And you can see down there that the definition of a person who counsels somebody is quite a broad definition. And so it's important to keep that in mind. All right, professional confidential relationship privilege. So these are records that can also be protected, and they are communications that are made in confidence within a relationship where where it's a professional capacity, and where the confidant is under an express or implied obligation not to disclose. And so in these circumstances, the protected confider can ask that evidence not be admitted into court. And what will happen is that the judge will weigh up and assess that potential harm against the desirability or need of that evidence being given or produced in court. And most often this is a feature of a counsellor-client or patient relationship, but it can be much broader than this, including through to GPs and nurses. And this privilege can be argued in family law and all other proceedings. All right, last couple of slides very quickly. So medical records can be used across broad types of legal matters. So you might see your medical records being called in during criminal proceedings. So it might be that there are charges relating to a sexual assault matter, and the records might be called in as evidence of both the assault or the charge, or to prove the assault or the charge, and or to prove injury. They might be used in civil proceedings. So, when we act for people in institutional abuse cases, then we would go back and look at all of their medical records and pull those records in to use perhaps as evidence of the act of violence or the assaults, but also most often in terms of proving that injury. And in other quasi-legal proceedings, such as in a victim support claim or in the tenancy matter that I talked about earlier. All right, and as I said, it could be used as evidence of an assault or evidence of that injury, the harm, the impact, or the mitigation of an injury by way of getting treatment. Okay, so I'm just wanted to flag with you the certificate of injury form. So often our clients will ask their GPs to help them by completing a certificate of injury form so that they can get recognition, payment or financial assistance from victim services. And your role in being able to just complete this fairly basic form to just identify that you've seen a patient on particular dates and this is what they said happened, and this is what you say in terms of their presenting symptoms and or any diagnoses, is a really integral part of their process to obtain victim support. And so any assistance that you can provide in terms of completing this certificate of injury form is really valuable for many of our clients. And the declaration by a competent person. So a GP can complete a declaration if in their professional opinion the tenant is a victim of domestic violence that occurred during the tenant's current tenancy, and that can then be grounds to terminate the tenancy so that they're not liable to continue living in that property and bearing the consequences or the risks of being a tenant in a house, particularly if they don't want to keep living there, and also then not bear the consequences having left of that tenancy. And my final is just to flag for you our GP toolkit. It's available on our website, and really it's there to support you when she talks to you about the violence around questions and the skills that you might need to make sure that you're able to best support her to give the very best disclosure that she possibly can around her violence. So thank you very much for your time and for having me here this evening. I'm going to stop sharing now.
Thank you so much, Pip. I'm going to open up to the panel in a second, but there's just a couple of really relevant questions that you might be able to answer quickly. Somebody asked how much notice might be enough notice. I think this is for a subpoena, and is there a general guide or rule of thumb? And somebody else asked, do the privileges apply to psychologist notes too? Both really good questions.
Yeah, the notice, and feel free to jump in, Rocky, but I think it's normally about 21 days, but it does differ across different courts and jurisdictions. But sometimes there's short notice that's given. So if there's some urgency in a matter, sometimes there'll be short notice, or solicitors will argue that documents should be returnable within a shorter period of time. But those subpoenas will note in them what's the latest date for you to produce documents, or what's the date that you need to turn up to give that evidence. And what was the second question, Moo?
The second question was, do the privileges apply to psychologists' notes too?
Yes, they do, but you have to assert them. So you have to assert those privileges, and then the judge will do that. Will weigh up whether or not that evidence is available anywhere else, whether or not that the producing of those documents is likely to irreparably damage that confidential and important and safe relationship that is often a very important part of the relationship between a patient or a client and their counsellor. And so, you know, hopefully judges will find that evidence is available elsewhere, but sometimes that evidence does find its way in. But at that point, what can happen is the judge can make some decisions about how that evidence is then used, and any limits. So it might be that there's a limit on no photocopying of that evidence, or that only legal representatives are able to view it and can't take copies of it, so that perpetrators like John can't access those types of records.
Thanks, Pip. And I see that Libby's joined us again. Fantastic. So I might run back through a couple of the questions that we got earlier. Firstly, somebody asked, what can be done about the types of abuse that are non-physically violent? So we've answered that a little bit, but I'm wondering if any of you on the panel would like to respond to that.
These other types of violence, abuse, maybe we call it abuse, you know, is very relevant. It's having an impact on the person. And in fact, numbers of states are looking at the moment to legislate that coercive control is an illegal act. I think that's not going to be an easy thing to do. But certainly they are well recognised as being forms of abuse, and we may be supporting the patient, or we may be getting this patient to be supported through one of the domestic violence agencies.
Yeah, thanks, Libby. And another question was, what if the patient discloses acts that suggest that they too are perpetrating violence in return? I'll throw that open to all three of you. It's a good question.
Well, what happens when somebody attacks you is that you usually try and protect yourself. So where there has been violent behaviour in intimate partners, between intimate partners, then it is highly likely that the victim will have tried to protect themselves. And it has certainly been used by the perpetrators of the violence to try and get other people to believe that the victim is in fact the person perpetrating the violence. And that certainly happens, and certainly people get misrepresented in that situation. For example, when the police arrive and the person who actually is the person venting the violence manages to convince the police that it's really the victim.
Yeah,
Yeah,
absolutely.
thanks.
Pip, I wonder if there's anything you'd like to add to that, because you see a lot of this, don't you?
Yeah, we do, sadly. And thanks, Libby. I think, you know, you've really well answered the question. I think it's about looking at the entire history of violence and abuse, and it's you know, domestic and family violence is about power and control, and certainly there are instances where women may in fact fight back, and may in fact they may be charged with domestic violence offences or end up with an apprehended violence order against them. But in fact, what is incumbent upon police is to look at, well, who's the primary aggressor in this relationship, and who's the primary victim. And often what will happen is, even when there's an incident where the police might turn up and the bloke might have a scratch mark down his face, in fact, what we find often is that it's the woman. There's been an incident, there's been violence, she's had fears, she's been assaulted, she's acted in self-defense, and she calls the police, and yet the police do fail to then ask appropriate questions and really unpack what it is that's happening that evening, but also importantly through that relationship, and to look back at police records and to really do that proper questioning.
Thanks, Pip. Rocky, I think this is one for you. In relation to subpoenas, what do you do if you're on leave? For example, extended annual leave or maternity leave, do you still have an obligation to provide notes if there's a subpoena?
Yeah, I would think, I mean, if you are overseas and things like that, and sometimes these come with such short notice and it would be physically impossible for you to do them, or on maternity leave. And we have had doctors ask this question. I think it's important to have those processes in place for when you leave, just like any other patient management type role. And generally, if you're working in a practice, the practices can get in touch with the requests, or they will be coming in and somebody will be looking at the requests addressed to you. And I think that it's important that if one does come in, the practice, or you have somebody able to deal with it, but also then get in touch with the requester, so the person who is requesting the subpoena, let them know who is getting in touch and who is complying with this and the reason why.
Yeah, thanks, Rocky. So just opening it up to the audience, are there any more questions that you have for the panel? I've got a couple more here while you're having a think. Do I tick do not send to my health record when recording abuse? I'm not sure if that's, I think that's probably one for you, Libby, or maybe you, Rocky.
Well, you will be asked at times not. So if you say diagnosed that this patient's involved in some form of domestic family domestic abuse and violence, you may have recorded that in your records, but it may not be appropriate for that to go in every letter you send. For example, in medical records now, when you write the letter, all your diagnoses go in, and so but you can tick that this is confidential, so that you're not sending it out to all and sundry, only where it is appropriate. What do you think, Rocky?
Oh, I think Rocky might have frozen.
Yeah.
We may have lost him. I'm going to keep going with the two esteemed panelists that I have, and hopefully he'll join us again. A question: what happens if I dispute a subpoena? Pip, maybe you can give us a bit more detail about this process.
So if you dispute, so you're required to produce the documents, and you produce them in a sealed envelope to the court. But what you would do is, if you're intending to dispute them, you would return them to the court with a letter that says, I object to the production of these records, or that I would like the court to exercise its discretion and manage these records in particular ways and for these particular reasons. And then the judge or the magistrate will look at that and will then determine whether or not he or she allows those records into the proceedings. So you'd send the letter, and then you would turn up. Usually you would be required to appear and explain to the court why it is that you're objecting to the production of those documents, so that the judge or magistrate has got a chance to ask you some questions why, and for you to explain it.
Thanks, Pip. Rocky, you're back, I think. Another question for all of you, or any of you. What happens if I'm seeing both the victim and the perpetrator? I imagine this will happen quite a lot, particularly where there are, family practices, or where people are in regional areas and there are only one or two GPs if you're lucky. Libby, any comments on that?
Yes, I think this is something that as GPs we need to learn to manage, because you cannot manage both people. It's not possible. No other organisation tries to manage both people, and you'll get two absolutely different stories. And we've had some terrible consequences of this. In Queensland, it happened, where the GP was managing both. The outcome was that he killed the wife and he ended up in prison. It's not a good outcome of patient care.
I would agree with you, Libby. And I was just talking with somebody today, another lawyer, who told me a story about a GP practice where they were treating both the husband and the wife had disclosed a history of domestic and family violence, and the practice had taken a record of that, taken that seriously, noted it and flagged it. But what that flagging did, and he had strangled her, and so that was literally a red flag on their system. And one day the two of them were in there together in the practice for something else, and the doctor turned the screen around to show whatever record was there, without realizing that what happened was this actual big red flag saying this, domestic violence victim, and that led to terrible consequences for her as well. So I would really, really caution you against working with both parties.
And if she was strangled, then she is 7 times more likely to be killed. It's a very, very red flag.
Yeah.
Yes, people say, well, how do I manage this? You need to have a discussion within your practice about how you're actually going to manage it. And in order not to, for the perpetrator not to realise what's going on, you may need to get the victim looked after by somebody else. And if you're in a country practice, you may need to use something like 1-800 RESPECT to be working and with the victim, or you maybe actually need to get the victim to go to a practice in another adjacent town. It's very important that we don't. It can be an absolute disaster, because it's impossible to do in a way that cares for both people.
Thanks, Libby. And that kind of answers another question that's come through. Is it appropriate to ask one party to see another practitioner, or which patient do you pass on if you're seeing both parties?
Well, yes, I think you may need to pass on the victim. It just depends. You can discuss that with the victim, but you don't want to alert the perpetrator to the fact that this violence has been this violence or abuse has been disclosed.
I'm very aware. Yeah, go on.
Can I just talk in terms of hospitals and privacy as well? It's very, very common in hospitals for records to be pinned at the end of beds or put into, you know, those plastic sleeve kind of containers, and then the records just get put in there. We've had experiences where our clients have been in hospital and then perpetrators have turned up and they've looked at those records where there's been disclosures of domestic and family violence. So again, I just encourage you to just be really mindful of those records and the safety risks. You know, not only are you're breaching your client's privacy and confidentiality, but you're exposing them to very, very real risk by records sitting out in public places.
Thanks, Pip. I'm very aware of time. We have one more audience question that I would love somebody to answer quickly. If a client requests the records, can privileges still apply?
If the what? Who?
If a client is requesting the records, can privileges still apply?
I would imagine so, but the privilege sits with the patient. And so if the patient wants her records produced for whatever reason, then it's her privilege that she's releasing. It's not the health practitioners, as much as, you know, that it may feel like it is. They're her records. And so what I guess I would do, you know, when our clients want to release their own client solicitor privilege, you know, we talk with them about the potential consequences and risks of that, but ultimately that is their decision at the end of the day if they want to waive their privilege.
Thank you, Pip. I'd like to say a huge thank you to all three of you. We've run out of time, of course, because it's such a fascinating topic and there are so many really good questions that we could continue answering in this space. I'd like to thank all of you for attending as well, and a reminder that there'll be a survey that pops up in your web browser just after this. I'd really strongly encourage you to click on the QR codes on this slide. There's a lot of information available on each of the PHN sites about local support options through those QR codes. And we'll be sending all participants a number of resources, including the GP's toolkit, which will help with some of the questions around how to ask, how to broach those conversations. That will come through to you after this. Your local health pathways has extensive information on supporting patients experiencing domestic and family violence, and recording of this session will also be on the respective PHN's YouTube channels. Just a quick reminder that there is another event in a couple of weeks' time, the Should I, Shouldn't I, when to report and share information about children and adults at risk from domestic and family violence. That's in 2 weeks' time. And please register for that if you haven't already. It's so important that we talk about this. Domestic and family violence is no longer a hidden private family matter. The more that we talk about it, the more that we start to break down some of the stigma and the barriers, the better we will get at changing attitudes and behaviours. If anything that we've talked about tonight has raised issues, please remember 1-800-RESPECT. It's the National Sexual Assault and Domestic and Family Violence Counselling Service, and of course the Doctors' Health Advisory Service that provides crisis support as well. A huge thank you to everybody. My apologies that we're running a couple of minutes late, but thank you so much to everybody who has stayed right till the very end. And please don't forget to fill out that survey at the end, particularly if you want to get your CPD points. Thank you again, panel.
Thank you.
Thank you, Moo. Thank you, Moo, very much. Thank you, everybody.